right.
Please be seated, counsel. We're here this morning for the second matter on our calendar. It is State of Washington versus James Manuel. And before counsel, you begin, thank you very much for participating today with the masks. We appreciate that. We know how uncomfortable it is to be in this position. Also, we are going to sanitize the podium in between speakers. So before you approach the bench, please let staff have time to clean the podium. All right, if we're ready to begin, counsel, you may approach.
Thank you, Your Honor. Good morning. Vitaliy, may I please the court? Vitaliy Kertchen, representing the appellant in this matter, James Manuel.
And how much time would you like to reserve for rebuttal?
I would like to reserve 4 minutes, please.
4. All right.
And Your Honor, the purpose why we're here today is a firearms petition that Mr. Manuel filed in King County. And really, we're not arguing about the merits, really, of the petition themselves. There's no dispute that he's eligible, rather the authority of the court to issue the order as we were requesting it. And we're dealing today with RCW 941-040, subsection 4B, which states that a person who's prohibited from possessing a firearm may petition the court of record. It may file a firearm petition only at the court of record that ordered the prohibition or the superior court of the county where they live. And the crux of our argument today is that this is an enabling statute. It gives a court authority. It does not limit that same court's authority, as the state essentially will be arguing. Once either one of those subparagraphs I or 1 or 2 apply, that court, whichever one it is, now has full authority to consider the merits of the petition. The argument essentially by the state is that, well, you have to file either one petition in the county where you live, and you can list all your convictions on it, or you have to go county by county by county by county if you have convictions in multiple counties. But the statute, the clear language of the statute simply doesn't support that reading. There is nothing in there that says only at, or, it doesn't say each court of record, it doesn't say every court of record, it just says only at the court of record or the superior court where the petitioner resides. Court of record, by the way, isn't really a particularly important term in this case. We're just talking about superior courts. For whatever reason, the statute uses 2 different terms, the court of record and the superior court, but really that's the same thing in this particular context.
But under your theory, a court of record includes a district court, right?
No.
A district court is not a court of record?
No, ma'am.
I mean, the justices of the peace didn't used to be courts of record, but I'm pretty sure district courts are courts of record.
District courts are not courts of record, Your Honor. I cited the RCW. It is RCW 2.08.030. That's superior courts. 2.06. This is footnote 3 on page 3 of my opening brief. This court is a court of record under RCW 2.06.010.
I'm sorry, slow down. So you said 2.08.030.
Yes.
That relates to district courts? No, that's superior courts. Yeah.
And then 2.06.010. That's this court of appeals.
Mm-hmm.
And 2.04.020. That's our Washington Supreme Court.
So those are the only courts of record.
Those are the only courts of record. District courts are not courts of record.
So in essence, you're saying because the Court of Appeals in the Supreme Court is not the courts that order a prohibition on the possession of a firearm, the phrase the court of record can only mean superior court.
Yes, ma'am. So one of the principal tenets of statutory construction is the legislature uses the words it intends to use, and it does not use words that it does not intend to use. And so the state's essentially asking the court to read into the statute something that isn't in there, and that would be a violation of the principles of statutory construction. It also results in an absurd result because, for example, if you consider a person, let's say they have a felony conviction in 4 different counties in Washington, they move to Oregon, Under the state's interpretation, now they have to waste the judicial resources of 4 different superior courts for a non-discretionary function. That's actually something important that the court should consider. Back in 2003, Division 2 ruled that this is in State v. Swanson, that the petition to restore firearm rights is a non-discretionary ministerial duty.
Well, isn't that the reason that the defendant can go to the court where he resides? To avoid having to go to all the other courts.
Well, in my scenario, he can't, though, because he no longer lives in Washington. That's my point. That's the point I'm trying to make, that that could result in an absurd situation where a person who no longer lives in Washington, that really Washington State shouldn't even really care about, they don't live here, but they're trying to restore, and they got to go do 4 different counties, and now they've got to waste judicial resources of 4 different counties over something that nobody has any discretion over anyway. It doesn't really make any sense. So our principal argument, again, is that essentially the statutory scheme 4B creates 2 co-equal options. You can either go to the court where you were sentenced, and the court has full authority to consider all of your criminal history, or you can go to the county where you live. And the legislature did accomplish something with its amendment, because prior to this, it was a free-for-all. There are 39 counties. There are 39 counties in the state. And without that particular new provision that was passed in 2011, it was a free-for-all. A petitioner could file in any of the counties. No nexus was required.
So why is court of record used and superior court used both? Why are those not 2 different things again?
You'd have to ask the legislature that. I think that's
Why shouldn't we assume that that means something, and perhaps it means what the state says it means?
I don't think the state. I think the state's in agreement that court of record and superior court, we're talking about the same thing. I think when he comes up here, he'll.
Well, isn't he saying court of record means where the actual offense took place?
But the terminology.
You can answer when you come back.
Okay. When I come back?
Yeah.
Okay. I'll probably forget by then.
We'll remind you.
Just perhaps and good morning, Your Honors, and may it please the court. My name is Gavriel Jacobs on behalf of the King County Prosecuting Attorney's Office. I think both counsel and I agree that this is a relatively this is a relatively simple matter of statutory interpretation, but I think somehow we diverge from there. To me, the language is fairly straightforward. We're only talking about subsection 4B1, and it says a person has to go to the court of record that ordered their prohibition. So if you think about this...
Let me stop you for a minute, though. Is it your contention that this statute is a, quote, subject matter jurisdiction statute, and that superior court's jurisdiction is limited by this language?
I think, yes. I mean, I think the superior court only has they only have the power that's given to them by the legislature.
Well, are you aware there is a line of cases that say we cannot interpret a statute to divest a superior court of original jurisdiction because you can't give jurisdiction. The legislature cannot, under the Constitution, give jurisdiction to one county superior court and deny it to another. Once the superior court has original jurisdiction, it has jurisdiction. I mean, I think this is really a venue statute. Wouldn't you agree?
Well, actually, on second thought, I think the court is probably right. I think I was probably just mixing those 2 terms up.
Okay.
I would note that regarding the earlier conversation about whether district courts are courts of record, I think counsel is technically right that I think superior courts are the courts of record. I would point the court to RCW 3.66.0101, which specifically states that district courts are provided with all the necessary powers possessed by courts of record. So I don't know if they're technically not courts of record, but the legislature specifically endowed them with the powers that courts of record have. And I think when you look at the language of the statute, it's in terms of individual convictions. It doesn't say if the legislature wanted to have the result that the defense is saying, it could have said a court of record that ordered a prohibition. Instead, it said the court of record that ordered the petitioner's prohibition, and it's a pretty standard element of statutory interpretation that the definite article is a limits. It's referring to one particular item in a class of things. And
So
here,
how does that fit with counsel's hypothetical, where you no longer live in Washington and you have convictions in several counties?
well, the legislature wants you to go to all 4 counties, and just because the court thinks it might not be the best use of resources or it might not be the best way to do things doesn't change the plain language of the statute. Something's only absurd if basically the court's saying the result is so ridiculous that the court could not have meant what they're actually saying. Just because,
How can you partially restore somebody's gun rights? I mean, this to me, it's like you either have your civil rights or you don't, right? I mean, I don't understand how you can partially do that.
well, because the statute is written to go conviction by conviction. So, for example, if you think about it this way, the way the statute is written, for each conviction, you have to, one of 2 things has to happen. You have to get it restored in the court where you live, or the court that ordered the prohibition. For those 8 Pierce County convictions in Mr. Manuel's case, neither of those things happened. It wasn't heard by the court where he lived, and it wasn't heard by the court that ordered the prohibition. So by the plain language of both subsection 1 and
Take a look
2.
at the language. The very first sentence says an individual may petition a court of record. They use the indefinite article.
Yes.
A court of record. And then they say only at small 1, small 2. And small 1 is the court of record that ordered the prohibition. So why isn't small 1 really modifying the phrase a court of record? So if you're going to pick a court of record, it has to be at least a court of record that issued an order prohibiting you from possessing a gun. Why isn't that just as reasonable of an interpretation as the one that's advanced by the state, in which case we're in ambiguity land here?
Well, if we're in ambiguity land, then we can go to elements of statutory interpretation. And the state, in my brief, I cited the bill report, citing some elements of legislative intent that suggest that this is what the legislature wanted. They wanted
Yeah, but isn't that a problem from perspective of the legislative intent is, well, you should force them to go to Pierce County because there might be a gang database that the judges in Pierce County could then evaluate whether this person is still a risk to the community. When we have the Swanson case saying, this is a ministerial function. This is not a discretionary decision. So you have some legislative history you're citing that seems inconsistent with what the court has said this statute is all about.
So I think what the legislature is saying, I don't know exactly about gang databases, but what the legislature is getting at is the discretion doesn't change, but the information available to the court may change.
How can that be? Every judge in the Superior Court has access to the same JIS and JOBS information.
And then it makes no sense for the person to be able to go to the county in which they live because
Exactly, and of course, but just because there's one hole in the statutory language that the defense can find doesn't mean you throw out the entire plain statutory language.
is it a hole or is it an explanation?
I would submit that it's a hole, that there's certainly a loophole that defendants can find, but that doesn't necessarily mean that you ignore the other plain language of the statute. To get one of the requirements to get your firearm right restored is all the conditions of sentence have to be fulfilled for non-felony convictions. It might be much easier for, if you have no connection to King County except maybe some other felony conviction, how is King County going to know if you're a Pierce County conviction if you completed all the terms of sentence?
Well, that's what the prosecutor certified. We've got the prosecutor saying, yes, this person is eligible. In other words, certifying that the 3 requirements have been met.
Well, in this case, but hypothetically, if say he hadn't gone anywhere before and he just decides to go to, down to some other county where he has where he has a prior conviction, hasn't gone anywhere else, how is that court supposed to find out, if he's met all the conditions of his sentence?
Whose burden is it to bring that information to the court?
I mean, it's the defendant's motion.
Well, then that's how the court would find out. If the court didn't have the information, then the court would say, no, I'm not going to restore your gun rights.
Well, but if it's a ministerial function, obviously what the legislature is asking is it wants the trial courts, the superior courts, to have the maximum amount of information possible to make.
Right. So if a defendant shows up with certificates of discharge from the clerk's office in every other county to provide the proof that Judge Smith was talking about, would that be sufficient? If he brought in certificate of discharge as to those Pierce County convictions to the hearing in King County, would that have been sufficient?
It may have been in this particular factual case, but of course, I don't know if you get certificates of discharge for misdemeanors, which is where you typically which is where the conditions of sentence language is in the non-felony section of the statute.
So is it your position that the prosecutor below did not, in fact, render a determination that Manuel was eligible based on the completing all of the convictions?
No, I'm not disputing in this case that this particular defendant was eligible, but I'm saying that.
So somehow the King County prosecutor was able to verify that the Lakewood Muni Court DV conviction had been completely dealt with.
Well, I don't know what the prosecutor certified. No, the state below was not contesting his eligibility. What research the prosecutor did or whether that could have been erroneous is a different issue. But clearly the legislature wanted the court to have available, access to as many databases
How's
as
the Pierce
possible.
County Superior Court going to have better information than the King County Superior Court? What's
Or the
base-
county where he lives, if there are no
Right, if he lived in Lewis
convictions.
County, how would the Lewis County Superior Court have a better access to Muni Court information from a Lakewood Municipal Court conviction than Pierce County Superior Court judge would?
It may not. It may not. But the fact that there's other holes in the statute for that a defendant might be able to go through doesn't lead to ignoring what the plain language of the subsection is. And the legislature.
Well, except you're advancing an interpretation of the statute and you're using arguments that don't seem to have a lot of strength, because you're saying, well, you have to interpret small one to mean this because the King County judge might not know the accuracy of the information about a municipal court conviction. But that's the case no matter where you go.
Well, what's happening is that was what the legislature thought, and that's what the legislature wrote. And just because there might be holes in the legislature's logic doesn't necessarily mean that you get to ignore the plain language of the statute that they've written. You still have to follow the plain language of the statute that's been passed. The fact that there may be flaws in the logic or other loopholes that the defendant can go through to get their firearms restored doesn't change the fact that the legislature specifically said you have to go to the court that ordered the prohibition. And that ultimately that's the plain language, this plain statutory language that we're left with. So I
Do
don't.
you agree if we get past the plain language and think it's ambiguous, and we don't think your legislative history provides us with a lot of help, do you agree that the rule of lenity kicks in and that weighs in favor of Manuel?
I mean, the rule of lenity is obviously the last stop in the chain of statutory interpretation, but yeah, if the court gets through everything and ends up at the rule of lenity, obviously I think the rule of lenity is a rule that favors the defendant's interpretation. So with that, I have waived my last 4.5 seconds.
Thank you so much. Mr. Kertchen.
Thank you. Well, I think the panel did a lot of the work for me. Thank you. But to pick up where I left off, the terminology, we didn't hear really any argument from the state regarding terminology issue in terms of what does court of record mean.
Well,
So if that's
court of
still-
record means the court that issued the sentence is basically what the state is saying.
The use of the definite article, the court of record, that issued the order prohibiting possession of guns. That's the state's argument, that the use of the definite article limits which courts of record Manuel can file the petition in.
I agree that their argument is predicated on the article the, but not court of record, because Judge Smith asked a question earlier, well, is that a difference between a superior court and court of record? I would argue there is not, and I don't think the state argued otherwise. But yes, back to the. Actually, I think the helps my argument because the statute doesn't say the courts of record, implying that there should be more than one petition filed in every court that ordered the prohibition. It doesn't say every court of record that ordered a prohibition. It doesn't say each court of record. It just says the court of record. And so that is actually an indication by the legislature that should only be one paperwork should only be filed in one place, either the county of residence or the county of conviction. We don't need to do multiple petitions. It doesn't make any sense.
Is there any indication that, from whatever you've read in the legislative history, that the legislature even contemplated a circumstance where there would be multiple convictions from multiple jurisdictions? And is there any discussion about what would happen if somebody had a conviction in Lewis and Whatcom and Skagit and Thurston?
No. we all wish that the legislature would maybe be a bit more thoughtful before it passed laws, but it oftentimes isn't. And so, no, I've not seen anything in the legislative history about those specific types of discussions. This was mostly a effort by the police lobby, for whatever reason, to create this thing because of gang databases and history. Apparently, nobody paid attention back then that, oh, by the way, this isn't really a discretionary function. Gang databases don't matter. So the answer to your question is no. In terms of jurisdiction, you pointed out, Your Honor, Judge Andrus, that is this really a jurisdiction or a venue? If you look at my briefing closely, I never used the word jurisdiction or venue. I used the word authority because you point out an excellent point. I don't really know. I will point out that, and I filed a statement of supplemental authority. There was a Division II case, State v. Burke. Very quickly, I'll quote, Article 4, Section 6 of the Washington Constitution grants Superior Court's original jurisdiction in all criminal felony cases and in all cases of all proceedings in which jurisdiction shall not have been vested by law exclusively in some other court. It goes on to say Superior Courts have brought constitutional jurisdiction over matters like petitions to restore the right to possess firearms. So at least Division II did kind of tangentially address that issue. I think this probably is more of a venue thing than a jurisdiction thing. Finally, if we do get past the torrid legislative history, if the court finds ambiguity and it gets past the non-helpful legislative history, we are into the rule of lenity. We have the Paisano case from Division II. We actually have a couple of cases already applying the rule of lenity in this context. And so if we do get to the rule of lenity, certainly Mr. Manuel wins on that issue. So I think that's all I have, unless there are any further questions. I only have 8 seconds.
Thank you very much,
Thank you.
counsel. The case is submitted, and we will be in recess. It's my understanding that we will be in recess until 11 a.m. All right.